Good morning, I'm Gary DeWaal, and this is Bridging the Week for April 22nd through 26th, and today is April 29th, 2019. New York regulators continued an aggressive streak against entities engaged in virtual currency businesses when the New York Attorney General's office obtained an ex parte order precluding companies associated with a cryptocurrency exchange and a stablecoin from utilizing fiat currency reserves backing the stablecoin to help fund operations of the well-known international exchange. The New York AG alleged that the respondents had previously engaged in such activities without disclosure to customers. Separately, the Department of Justice determined not to retry the purported programmer to the flash crash Spoofer following the mistrial declared by the judge overseeing the criminal trial of the programmer earlier this month. Hard to believe that May is just around the corner, and we have already completed 4 months of 2019. So I can hurry up and finish my year-end holiday shopping before 2020 begins. Let's get started. The Office of the Attorney General for the State of New York obtained an ex parte order from a New York State court prohibiting companies associated with the management of the crypto asset exchange Bitfinex, as well as the stablecoin Tether, from accessing, loaning, or encumbering in any way U.S. dollar reserves supporting Tether digital coins. The New York AG claimed that the same individuals ultimately owned and operated all the companies. The New York AG had applied for such order without notice to respondents and they're having an opportunity to object, claiming such emergency action was necessary because of the potential danger of respondents to compromise Tether supporting balances to help fund operations of Bitfinex. Stablecoins backed by fiat currency, such as Tether, are a type of virtual currency that are intended to be supported one-to-one by the relevant fiat currency or cash equivalents held in escrow, typically at a bank or other financial institution. According to papers filed by the New York AG, by mid-2018, Bitfinex experienced quote-unquote extreme difficulty satisfying clients' requests to withdraw money from their trading accounts because a payment processor where it maintained customer proprietary funds failed to process customer withdrawal requests and would not or could not remit any funds to the crypto asset exchange. Specifically, as alleged by the New York AG, Bitfinex was unable to retrieve $851 million from the payment processor because it claimed that the, quote, funds had been seized by governmental authorities in Portugal, Poland, and the United States, end of quote. In response charge to the New York AG, executives of Bitfinex and the company managing Tether, also known as Tether, agreed for Tether to provide Bitfinex a line of credit of up to $900 million sourced from the US dollar reserves supporting the Tether stablecoin in order to help meet Bitfinex's customer withdrawal demands. However, this arrangement, asserted the New York AG, was made without disclosure to Tether's stablecoin holders. To date, claimed the New York AG, Bitfinex has already borrowed $700 million from Tether, utilizing Tether supporting balances. The court's order also required respondents to safeguard certain records and to provide certain documents to the New York AG. Other than requesting this specific relief, the New York AG did not seek to interfere in any manner with Bitfinex's or Tether's day-to-day operations. In a press release issued on April 26, Bitfinex said that the New York AG's filings, quote, were written in bad faith and are riddled with false assertions. Both Bitfinex and Tether are financially strong, full stop. End of quote. A scheduled hearing on this matter is scheduled for May 3rd. Earlier this month, the New York Department of Financial Services canceled Bittrex Inc.'s temporary authority to conduct a virtual currency business in New York, denying its application to obtain a BIT license, and explained its actions in a letter to Bittrex that the agency publicly disseminated. Bittrex and Bitfinex are not related. This matter involving Bitfinex and Tether threatens to have implications beyond just the companies and customers involved. A lot of the activities engaged by Bitfinex and Tether currently appear unregulated or regulated in a very indirect way. The Department of Justice determined not to re-prosecute Jitesh Thacker, the alleged programmer of purported flash crash spoofer Navinda Sarao. This decision followed the declaration of a mistrial on April 9th by the judge who presided over the criminal trial of Mr. Thacker. Previously, the judge, the Honorable Robert Gittleman of the United States District Court for the Northern District of Illinois, acquitted Mr. Thacker of the criminal charge of conspiracy to commit spoofing. The jury hearing Mr. Thacker's case additionally voted 10-2 against convicting him of 2 counts of aiding and abetting spoofing. It seems appropriate, based on this outcome, for the Commodity Futures Trading Commission to now drop its civil enforcement action against Mr. Thacker. It seems unreasonable to hold technology providers responsible for the misuse of their products by third parties, absent their direct knowledge of proposed misuse. And finally, last month, the Division of Enforcement of the CFTC publicized a new initiative aimed at encouraging non-CFTC registrants to voluntarily self-report violations of the Commodity Exchange Act, the principal law overseen by the CFTC, involving foreign corrupt practices. According to the division, it would recommend to the Commission a resolution of their wrongdoing, quote, with no civil penalty, absent aggravating circumstances involving the nature of the offender or the seriousness of the offense, end of quote, for non-registrants who self-reported such violations, fully cooperated with the CFTC, and remediated their violations. At the time, it was unclear what might have suddenly prompted the unexpected introduction of this new policy more than 40 years after the adoption of the Foreign Corrupt Practices Act in 1977, which itself was 3 years after the authorization of the CFTC. Last week, the motivation may have become clearer when Glencore, one of the largest international firms involved with natural resources and the marketing of more than 90 commodities, announced it had been advised by the Commission it was subject to an investigation into whether it or its subsidiaries violated the Commodity Exchange Act in connection with corrupt practices involving commodities. Previously, one Glencore Group company was served with a subpoena by the U.S. Department of Justice for documents and other records regarding its compliance with the Act in connection with the group's business in Nigeria, the Congo, and Venezuela from 2007 through 2018. Well, that's it for this week's edition of Bridging the Week. As always, there's more information in each article and more articles on the article version of Bridging the Week on the website. Check it out. That's, by the way, www.bridgingtheweek.com. I'm Gary DeWaal. Have a great week, and until the next edition of Bridging the Week, ciao, and don't forget to hurry and do your holiday shopping.